how to report tax cheats and potentially receive large whistleblower awards under the IRS Whistleblower Program. Hi, I'm attorney Jason T. Brown. I was a former legal advisor and special agent with the Department of Justice and the FBI. I presently run the law firm Brown LLC. We protect whistleblowers all over the world, all over the country. Also, we are an IRS whistleblower law firm, and there's a lot of conceptions and misconceptions about what you need to do to blow the whistle on a tax cheat and potentially be eligible for an IRS whistleblower award. Let's start with what you intend to blow the whistle on. And basically, you need to be blowing the whistle on a tax liability that exceeds over $2 million. So the entity that failed to pay taxes has to have at least $2 million worth of obligation to the U.S. taxpayers and the federal government for the IRS to consider it. Since the IRS is extremely busy, generally they triage, and unless there's some other interest at stake, they are not going to take the bare minimum right away unless and until you have highly itemized, granular, detailed information about the nature of the tax scheme and is presented in a very palatable, surgical manner. To report things to the IRS, you could do it informally. You could always call some of their tip hotlines, call the local office to do so. But if you do it in that manner, you will not, let me repeat myself, you will not be eligible for a whistleblower award. You could also report it to the FBI. The FBI or Secret Service sometimes if it involves certain treasury matters. Now again, if you report it directly to those agencies, they may treat you as a CI, a confidential informant. They may treat you as a CW, cooperating witness. They may throw a little cash your way, but you will still not be eligible for a big whistleblower award under the IRS Whistleblower Program. So if you want to report a tax cheat and potentially look for a big award, like anything else with the IRS, you need to fill out the appropriate form. If you don't fill out the appropriate form the right way, then at the end of the day, even if the government recovers hundreds of millions from the tax cheat, you're entitled to nothing. And a lot of times people come to our firm when it's too late. And when it's too late, it is too late. Even if you have all the information neatly ready about turning in the tax cheat, you still may never go anywhere unless you presented it in the right manner. So what is that form? The appropriate form to fill out is the IRS Form 211. Now, I am going to tell you that, but also tell you I strongly advise you to obtain a whistleblower law firm that knows what they're doing, an IRS whistleblower attorney, before interfacing with the IRS. Number one, it could give you a level of protection because technically you could be cloaked in anonymity throughout the entirety of the process. And number two, you really only get one first bite at the apple. And when you present it to the government, you want to present it in a package in which they will understand what you're talking about, or else they're just going to gloss over it and go to the next file. So that Form 211 needs to be filled out properly. And then after that, bang, the next day you're paid? No way. No way. These things take a long time. And it's a long, confidential route. Just like you, as the whistleblower, would be entitled to confidentiality, which isn't 100% guaranteed, but close to it with an IRS whistleblower attorney, the taxpayer themselves, the tax fraudster, they have rights also under the code. So the government is very unlikely to give you detailed information about the status of the investigation while it is going on. And seasoned whistleblower attorneys can pick up through the context clues about what, if anything, may be going on. For example, if the IRS decides to audit the entity that you believe has committed tax fraud, you may not be cued into that directly, but ultimately there may be something indicating, for example, that the IRS has made a determination and the defendant, if you will, the tax fraudster, is challenging that determination. So typically at that phase, it means that most likely the information you provided, or almost certainly the defendant that you provided, is the subject of some sort of underpayment in taxes that the IRS found they're liable for. Now, that's an administrative determination. They're entitled to appeal that result internally with the administrative board within the IRS, and then potentially it becomes public if they try to challenge it in federal district court. So going back to the first part of that, they may, but not must, the IRS may give you credit for being the one who blew the whistle and gave precise enough information to entitle you to up to 15 to 30% of what the government recovers through the tax penalties for the underpayment or lack of payment completely. So it could be quite a lucrative program if you have inside detailed information. And let me just delineate that even further. So, for example, during the intake process, if you call our law firm and if we handle an IRS whistleblower case, almost always we are going to handle it on a contingency basis, meaning we're only paid if we prevail. But we're going to ask you very specific questions to see what information you have. Is it that you just believe your neighbor is driving around a brand new Lamborghini and you don't know what the source of funds are? That's nothing. Is it that you have a suspicion that your employer is underpaying its taxes? That's not much. Is it that you think the employer is paying everybody's independent contractors when in fact they should be classified as employees? That can open up a whole body of law. That could be also an issue under the FLSA about appropriate classification of workers as employees versus independent contractors, but can also entitle the defendants to colorable defenses in which the government and the Department of Labor, IRS, may not view it as necessarily culpable conduct, but instead colorable, defensible type of conduct. But stuff we still want to hear about, but understand what is the extent of the potential tax liability there. Incidentally, I'll drop a footnote. There's also states like New York where you can report tax cheats and tax fraudsters, in which you also have additional rights if the tax scam is going on in those locations. But sticking with the IRS, you need to have that detailed information. So questions we would ask: how much was the entirety of the underpayment? How do you know? I mean, typically there's two sets of books for the more sophisticated enterprises. It's ironic that the criminals always keep the second set, but they do. Because the second set of books, the one that they don't show the government, shows what their company is really making. And the first set of books, where they only generally share that information even with their accountant, says to the government what they claim they're making. So set number one of books, what they claim to the government they're actually making. Set number two, what they are actually making. And if they're claiming to the government they're only making, let's say, $2 million a year, but you know in the books, a lot of that activity is buried through subcorps, offshore accounts, complicated tax schemes that they may believe are lawful, but may on their face be unlawful, and their actual income is $5 million, and there's a $3 million a year liability, then you may have a case. If you know those predicate facts. Predicate fact number one, what did they report to the government their tax liability was? Fact number two, what in fact was their actual tax liability? Not guesswork, not I think it was around. It has to be, this is the number and this is the number, and here's how we get to the number, and here's why there's a $3 million deficit each year for the tax obligation. That's just wrong. And if you lack that type of information, we'll talk to you. We'll explain to you what information we need, which I think hopefully is extremely clear in this video. But it's doubtful a firm like ours would take a case like that. So then you get into the kind of issue about who is really in a good position to blow the whistle. Well, people in a good position to blow the whistle are generally high-level execs, insiders that work at the company, have access to the books, and maybe even work in preparing the books. Now, that work in preparing the books also creates its own little blend of challenges. Because if you're a CPA, you may owe a duty of loyalty. There may be some degree of privilege to the company that you work for when you're doing their taxes. And that's when it gets into tricky grounds. Is what the company doing outright legal, illegal? And when I say illegal, not just civilly and administratively, is it criminally illegal? If so, there may be no privilege whatsoever. But that's also an issue that needs to be determined. For example, if you're the company accountant and you're doing the books and you discover you believe that these independent contractors should actually be employees, well, that may be an issue subject to argument. If it's subject to argument, it may have some degree of privilege. If, on the other hand, you know that the company's claiming $3 million a year in deductions, and you start investigating and find out the deductions and invoices are fugazi, they're fake, there is no real money being paid, then that may be criminal conduct, and there may be no privilege that the company can expect to hold for that, and it could be very fertile grounds to make a report. Almost everybody wants to theoretically use the IRS as a weapon against their opponents, and the IRS is very sensitive to that. So if your motivation in blowing the whistle is to harm the other side, to disrupt the other side, generally unclean hands, impure thoughts don't succeed. However, it's always going to fall back on what is the content of the information that you intend to report to the IRS, and number one versus number two. What did they report to the IRS? What did they report to New York State? What was their real income and that they should have reported to the IRS? What was their real income that they should have reported to New York State or other states that have a tax code that remedies and allows whistleblowers to come forward? Hope you found this a little bit informative. You can fill out the Form 211 yourself. I strongly discourage individuals from doing that. If you do that yourself, you're going to probably wind up hurting the case, and it's going to go into the circular file. Can't promise that. Sure, there's certain people that probably have recovered without the use of an attorney, but you also want to make sure that you use the right whistleblower law firm as well. Case in point, one of the biggest IRS whistleblower recoveries, I'm talking about in excess of over $100 million IRS whistleblower award, involved an individual who used a different firm first and then a different firm second. And as a result of the filing in the first firm, it was thought that they then became the subject of the criminal investigation and got hurt in the process. The second firm rehabilitated it. So yeah, money's great. And particularly if you're receiving money for doing the right thing, doing the honorable thing. But there's nothing more important than your liberty. And those are things that you want to tease out and ferret out as well. Do you have any exposure if you do blow the whistle? And that's something that we will talk to you about if you consult with our firm. If you're thinking about blowing the whistle about tax fraud, tax cheats, either the IRS Whistleblower Program, New York State Whistleblower Tax Cheat Program, or other states' whistleblower programs, please contact our firm, 877-561-0000, for a free confidential consultation.